The ice dam on my roof started forming in late January, right after a brutal snowstorm dumped 18 inches of heavy, wet snow across northern Massachusetts. I live in Brookfield, a small town about an hour west of Boston, where winter weather can turn nasty without warning. The temperature had been doing that annoying thing where it climbs just above freezing during the day and then plummets at night, creating the perfect conditions for ice to build up along my roof's edge. By the first week of February, I had a solid ridge of ice about 8 inches thick running the entire length of my front roof line. I knew what it was. Everyone who lives in New England knows what an ice dam is. The warm air from your house melts the snow on your roof. The water runs down to the cold edge where it freezes again. And eventually, you have this massive buildup that can cause all sorts of problems. The smart move would have been to deal with it immediately, but I had just started a new job as a construction project manager, and my schedule was completely insane. I was working 12-hour days trying to prove myself, and honestly, the ice dam was not at the top of my priority list. That changed when I found the notice taped to my front door. It was a Tuesday evening, around 7 o'clock. I had just pulled into my driveway after another exhausting day, looking forward to heating up some leftover pizza and maybe watching a basketball game. The paper was folded neatly and secured with clear tape right at eye level. I could see the HOA logo printed at the top before I even pulled it off. "Dear Mr. Connor Ellis," it read. "It has come to our attention that your property at 428 Meadowbrook Lane is in violation of Section 7.3 of the Meadowbrook Commons Homeowners Association bylaws regarding exterior property maintenance. Specifically, an excessive ice dam has formed on your roof, creating an unsightly appearance that negatively impacts the aesthetic standards of our community. You are hereby fined $250 and must remedy this violation within 5 business days. Failure to comply will result in additional fines of $100 per day until the violation is corrected. Regards, Susan Pritchard, HOA President." I stood there in my driveway, cold wind biting at my face, rereading the letter 3 times. $250 for ice on my roof. Ice that was there because of weather I could not control. Ice that literally every third house in the neighborhood probably had to some degree. I crumpled the letter in my fist and went inside, my appetite gone. The pizza stayed in the fridge while I paced around my living room, getting angrier with each lap. I had bought this townhouse 8 months ago, my first real property after years of renting apartments in Boston. The HOA fees were steep at $300 a month, but the realtor had assured me it was worth it for the maintained common areas and the community pool. Nobody had mentioned that the HOA president was apparently running around with a ruler measuring everyone's ice formations. The next morning, I called the number listed on the notice. A woman answered on the 3rd ring. "Meadowbrook Commons HOA, this is Susan speaking." "Hi, Susan. This is Connor Ellis from 428 Meadowbrook Lane. I got your notice about the ice dam yesterday." "Oh yes, Mr. Ellis. Have you scheduled someone to remove it?" Her voice was clipped and efficient, like she was checking items off a list. "That's actually why I'm calling. I understand it needs to be dealt with, but a $250 fine seems excessive. It's winter in Massachusetts. Ice happens." "The fine is not negotiable, Mr. Ellis. Our bylaws are very clear about exterior maintenance. But this isn't a maintenance issue. It's weather. I didn't create this ice dam through negligence. We just had a major snowstorm." Several other homeowners managed to prevent ice dams on their properties through proper roof maintenance and heating cables. The fact that you chose not to take preventative measures is precisely the kind of negligence our bylaws address. I took a deep breath, trying to keep my cool. I've been at my property for 8 months. I've never received any notification about requiring heating cables or any other preventative measures. Ignorance of the bylaws is not an excuse, Mr. Ellis. You signed an agreement acknowledging that you read and understood all HOA rules when you closed on your property. The 5-day deadline stands. I suggest you contact a roofing company today. Goodbye. She hung up before I could respond. I sat in my car in the parking lot of my job site, phone still pressed to my ear, listening to the dial tone. Something about Susan Pritchard's attitude had flipped a switch in me. I had dealt with difficult people before. In construction, you run into demanding clients, stubborn contractors, and bureaucratic inspectors on a daily basis. But there was something about the combination of the arbitrary fine, the dismissive tone, and the complete lack of understanding that made my blood boil. I did some research during my lunch break. Roof ice dam removal in Massachusetts was not cheap. The quotes I found online ranged from $400 to $800 depending on the size of the roof and the severity of the ice buildup. So I was looking at potentially over $1,000 total when you factored in the fine. For ice, that would probably melt on its own in a few weeks when the weather warmed up. That evening, I actually went up on my roof with a ladder to inspect the ice dam myself. It was worse than I had thought. The ridge of ice was thick and extended back under the shingles in some places. I could see where water had started to pool behind it, though thankfully it had not leaked into my attic yet. But it was only a matter of time. If we got another warm day followed by a cold night, the dam would get worse. My townhouse was on the end of a row of 6 connected units. My roof sloped down toward the front, where my driveway and a small front yard separated my property from the street. Beyond the street was a large paved area that served as additional parking for the HOA. It was one of those community lots that nobody really wanted to use because it was farther from the townhouses, but the HOA maintained it anyway and counted it as one of the amenities that justified the monthly fees. As I stood on my ladder looking at the ice dam, I noticed something interesting. The way my roof was angled, if water did start flowing from melting ice, it would run down the front of my house, across my small yard, into the street, and straight toward that parking lot. The lot sat slightly lower than the street level, with a curb cut and a gentle slope designed to handle drainage. In normal weather, this was fine. But if a large volume of water suddenly came rushing down, that parking lot would flood. An idea started forming in my mind. A terrible, petty, probably stupid idea. I climbed down from the ladder and went back inside. I pulled up the HOA bylaws on my computer and started reading through them carefully. Section 7.3 did indeed mention exterior maintenance, but the language was vague. It talked about keeping properties neat and well-maintained in appearance and preventing hazards or eyesores that diminish property values. Nothing specifically about ice dams. Nothing about what qualified as an unsightly appearance. I kept reading. Section 9.2 covered HOA responsibilities. They were required to maintain all common areas, including parking lots, walkways, and drainage systems. Section 9.4 specified that the HOA was responsible for snow removal in common areas and ensuring proper drainage to prevent flooding. The next morning, I drafted a response letter to Susan Pritchard. I kept it professional but firm. I disputed the fine, arguing that ice dams were a natural weather occurrence and not a maintenance issue. I pointed out that the bylaws did not specifically mention ice dams, or require preventative measures like heating cables. I offered to remove the ice dam within a reasonable time frame of 30 days, which would allow me to save up for the removal cost and wait to see if warmer weather might partially solve the problem naturally. I sent the letter via certified mail and emailed a copy to the HOA email address. Susan responded within 2 hours. "Mr. Ellis, your dispute has been reviewed and denied. The original fine stands and the 5-day deadline remains in effect. As of today, you have 3 business days remaining to comply. If you fail to remedy the violation, additional fines will begin accruing at $100 per day as stated in the original notice." That was it. No consideration of my points, no discussion or negotiation, just a flat denial. I started asking around the neighborhood that weekend. I knocked on doors and chatted with neighbors I rarely saw, asking if anyone else had received notices about ice dams or other winter-related violations. What I discovered made me even angrier. My next-door neighbor, an elderly man named Robert Chen, told me he had received a similar notice 3 years ago about ice on his roof. He had paid the fine and hired someone to remove the ice because he did not want trouble. 2 doors down, a young couple named the Martins said they had received warnings about various things over the years. Christmas decorations left up too long, a lawn that was not green enough in summer, a small crack in their driveway. They had learned to just comply quickly to avoid escalating fines. Everyone had stories about Susan Pritchard. She had been HOA president for 6 years, running unopposed in every election because nobody else wanted the job. She was known for driving around the neighborhood looking for violations. She measured grass height with an actual ruler. She took photographs of minor issues and presented them at board meetings as evidence of declining community standards. "Just pay the fine and move on," Robert advised me. "It's not worth the headache." But I could not let it go. Maybe it was stubbornness. Maybe it was the principle of the thing. Or maybe I was just tired of people like Susan Pritchard wielding tiny amounts of power like tyrants. The 5-day deadline came and went. I did nothing about the ice dam. 3 days later, I received another notice. The additional fines had started. I now owed $250 for the original violation plus $300 in daily fines, totaling $550. The notice informed me that if the violation was not corrected within another 5 business days, the HOA would hire a contractor to remove the ice dam and bill me for the cost plus a 25% administrative fee. I wrote back, again disputing the fine and again offering to resolve the issue within 30 days. I pointed out that having the HOA hire a contractor would cost me significantly more money and seemed punitive rather than focused on actually solving the problem. Susan's response came the next day. "Your continued non-compliance is unacceptable. The HOA board will be voting at our next meeting on February 15th to authorize contractor intervention. You are welcome to attend the meeting to present your case." The HOA meeting was held in the community clubhouse, a small building near the pool that was used for events and gatherings. I arrived at 7 p.m. on February 15th to find about 20 other homeowners scattered around a room set up with folding chairs. Susan Pritchard sat at a table at the front with 4 other board members. Susan was exactly what I had expected. She was probably in her mid-50s, with short blonde hair styled in that specific way that seemed designed to say, "I would like to speak to the manager." She wore a navy blue blazer over a white blouse, and she had reading glasses on a chain around her neck. She looked like she had been born to run an HOA. The meeting started with routine business, approval of last month's minutes, a financial report, discussion of pool maintenance contracts for the upcoming summer. I sat in the back, waiting for my issue to come up. Finally, Susan reached my item on the agenda. Next, we have the ongoing violation at 428 Meadowbrook Lane. Mr. Ellis, I see you are here. Would you like to address the board? I stood up and walked to the front, suddenly aware that everyone was looking at me. I had prepared some notes, but my heart was pounding. Yes, thank you. I want to explain why I think this fine is unfair and why I have not paid it. First, ice dams are a natural occurrence in New England winters. They are not the result of negligence or poor maintenance. Second, the bylaws do not specifically require heating cables or other preventative measures. Third, the fine amount is excessive and appears to be punitive rather than corrective. I am willing to remove the ice dam, but I need reasonable time to do so. Susan did not even look up from her papers. Mr. Ellis, we have been through this via email. The board has reviewed your dispute and found it without merit. The bylaws clearly give us authority to enforce community standards. Your ice dam is visible from the street and reflects poorly on our neighborhood. But other houses have ice dams too. I have walked around the neighborhood. Why am I being singled out? Other violations will be addressed in due course. The fact that other homeowners may also be in violation does not excuse your non-compliance. One of the other board members, a man in his 60s, spoke up. Why haven't you just removed the ice? It's been weeks now. Because the quotes I have gotten are between $400 and $800. Combined with the fine, that's over $1,000 for ice that will melt naturally in a few weeks when the weather warms up. Susan looked at me over her reading glasses. Mr. Ellis, homeownership comes with responsibilities. If you cannot afford basic maintenance, perhaps you should reconsider whether you are ready for the financial obligations of living in a managed community. The condescension in her voice made my jaw clench. Several other homeowners in the audience shifted uncomfortably. I can afford maintenance, I said, keeping my voice level. What I object to is unreasonable fines for natural weather conditions. The board will now vote on authorizing contractor intervention, Susan announced, effectively ending the discussion. All in favor? 4 hands went up immediately. The 5th board member, a younger woman I did not recognize, hesitated and then raised her hand halfway. Motion passes. Mr. Ellis, the HOA will hire a contractor to remove your ice dam. You will be billed for the cost plus administrative fees. This meeting is adjourned. I walked out of that clubhouse feeling humiliated and furious. The casual dismissal, the refusal to even consider my points, the public nature of the whole thing, it all combined into a toxic mixture of anger and determination. That night, I made my decision. If the HOA wanted to play hardball, I would play too. But I would play smarter. I did more research. I looked up Massachusetts property law, HOA regulations, and liability issues. What I discovered was interesting. While HOAs had broad authority to enforce aesthetic rules, they also had clear responsibilities. They could not act in an arbitrary or discriminatory manner. They had to apply rules consistently. And most importantly, they were responsible for maintaining common areas and ensuring they did not create hazards for homeowners or the public. I also researched ice dams more thoroughly. They typically form over several freeze-thaw cycles. The dam itself can hold back a significant amount of water. When an ice dam fails, either from melting or from the weight of backed-up water, it can release hundreds of gallons all at once. The weather forecast for the next week showed exactly what I needed. A string of sunny days with temperatures climbing into the low 40s, followed by several nights below freezing, and then a big warm-up toward the end of February with highs expected in the mid-50s. Perfect. I called the contractor the HOA had sent to quote the ice dam removal and told him I would handle it myself. He seemed confused, but said he would notify the HOA. Susan immediately emailed me saying that I could not back out now, that the board had voted to authorize contractor intervention, and that she had already signed a contract on behalf of the HOA. I wrote back, "I have the right to maintain my own property. If you hire a contractor to do work I do not authorize, I will consider it trespassing." Her response was swift and venomous. The HOA has the authority under the bylaws to take corrective action when homeowners fail to comply with violations. If you interfere with the contractor, you will be in violation of additional sections of the governing documents and will face further fines. I did not respond. Instead, I went up on my roof and inspected the ice dam again. It had gotten worse over the past few weeks. The ridge was now over a foot thick in places, and I could see discoloration on the shingles underneath where water had been seeping. My attic had some water damage now too, small dark spots on the ceiling that would need to be repaired eventually. But that was my problem to deal with, not the HOA's. What I did next was technically nothing. I simply watched and waited. The contractor showed up 3 days later on a Thursday morning. I was working from home that day, reviewing project plans at my kitchen table. I heard a truck pull up outside and looked out to see 2 guys in work gear setting up ladders. I went outside immediately. "Can I help you?" I called out. The older of the 2 men turned to me. "We are here to remove the ice dam. HOA contracted us. I do not authorize any work on my property." He looked uncomfortable. "Look, buddy, we are just doing the job we were hired for. You need to take it up with your HOA. "I'm taking it up with you. This is my property. I do not give you permission to be on my roof. If you proceed, I will call the police and report it as trespassing." The 2 men looked at each other. The younger one pulled out his phone and stepped away, clearly calling someone. A minute later, he came back. "The HOA lady says they have the authority to do this work. She is coming over here to straighten this out." We all stood there in my driveway for about 10 minutes, the awkward tension thick enough to cut with a knife. Then Susan Pritchard's white Lexus SUV pulled up to the curb. She got out wearing yoga pants and a puffy winter jacket, her face already twisted into an expression of irritation. "Mr. Ellis, what is the problem now? These men are trying to work on my property without my permission. The HOA has authorization under the bylaws. We discussed this at the board meeting. The bylaws do not give you the right to trespass on my property. If these men touch my roof, I will call the police." Susan's face was turning red. "You are being completely unreasonable. We are trying to help you comply with the violation notice. I never asked for your help. I said I would handle it myself. You have had weeks to handle it and have done nothing." I smiled at her, which I could tell made her even angrier. "That's my choice as a property owner. Now, I'm asking you and these contractors to leave my property." The contractor who had called Susan looked at her. "Madam, if the homeowner is refusing access, we cannot legally do the work. We could be liable if he presses charges." Susan sputtered for a moment. "Fine. Fine. Mr. Ellis, you will be receiving additional fines for refusing to comply with HOA corrective action. This is now a violation of Section 12.7 of the bylaws regarding interference with HOA operations. Send me the notice. I will dispute it like all the others." She stormed back to her car, got in, and drove off without another word. The contractors packed up their equipment and left with apologetic shrugs. I went back inside, my hands shaking slightly from the adrenaline. I had just made things significantly worse for myself, at least on paper, but I did not care anymore. This had stopped being about money or ice dams. It was about principle. Over the next week, I received 3 more notices from the HOA. The fines now totaled over $1,500. Susan was throwing everything she could find at me. The original ice dam violation, daily non-compliance fines, a new fine for interfering with contractor access, and even a citation for having my garbage cans visible from the street for more than 12 hours after collection day. I did not pay any of it. I responded to each notice with detailed disputes, citing specific bylaw language and Massachusetts property law. I knew none of my disputes would be accepted, but I was creating a paper trail. Meanwhile, the weather was doing exactly what I had hoped. The sunny days were causing the ice dam to melt slightly during the day, allowing more water to pool behind it. Then the nighttime freezes were causing that water to freeze, expanding the dam and making it even more unstable. The dam was now a massive ridge of ice, at least 16 inches thick, running the entire 30-foot length of my roofline. I took photographs every day, documenting the growth. I also took photographs of the HOA parking lot, showing its normal condition. I wanted evidence of the before state. The big warm-up was forecast to arrive on a Tuesday. Temperatures were expected to reach the mid-50s with full sunshine. It would be the warmest day we had seen since early December. I checked the forecast obsessively, watching as the prediction held steady. That Monday night, I barely slept. I kept thinking about what might happen, running through scenarios in my head. There was a chance nothing dramatic would occur. The ice might just melt slowly over several days. But if the dam failed suddenly, if all that pent-up water released at once, the results could be significant. Tuesday morning arrived with clear skies and temperatures already in the low 40s by 8 a.m. I called in sick to work, telling my boss I had a plumbing issue at home that needed immediate attention. Not entirely a lie, depending on how you defined plumbing and immediate. I positioned myself at my front window with my phone and a good camera I had borrowed from a friend who did photography as a hobby. I wanted to document everything. By 10 a.m., I could hear water dripping. By 11 a.m., it was a steady stream in places. The temperature was 52 degrees and climbing. The sun was hitting my roof directly, warming the shingles and melting the snow behind the ice dam rapidly. By noon, I could see water pooling along the edge of the dam, finding every tiny gap and crack, running down in thicker streams. The ice itself was starting to look unstable, with pieces breaking off and sliding down to the ground. At 1:30 p.m., it happened. I heard a crack like a gunshot. A section of the ice dam about 6 feet wide broke loose and slid off the roof in one massive chunk, hitting the ground with a tremendous crash. Immediately, water began pouring out of the gap, not dripping or flowing but surging like someone had opened a floodgate. I grabbed my camera and started recording. The water was cascading off my roof in a torrent, hitting the ground and running across my small front yard. It hit the curb, flowed over it, and poured into the street. The volume was incredible, like watching a fire hydrant that had been knocked open. More sections of ice dam began failing, unable to hold back the accumulated water. Within minutes, my entire roofline was shedding water and ice in a spectacular display. The water was running in sheets down my driveway and yard, all flowing toward the street. The street itself was slightly crowned, meaning water naturally flowed toward the curbs on either side. The curb directly in front of my property led straight to that curb-cut entrance to the HOA parking lot. I watched as the water reached the street, formed into a fast-moving stream, and headed directly downhill toward the lot. The parking lot, as I had noticed during my earlier observations, was slightly lower than street level, and had a drainage system designed for normal precipitation. What was flowing toward it now was anything but normal. I grabbed my phone and ran outside, recording video as I went. The noise was incredible. Water was rushing past me like a river. I made my way to the street, staying on the high side, and followed the flow toward the parking lot. The water hit the curb cut and accelerated, pouring into the lot with the force of a small waterfall. The drainage grates, designed to handle rainwater, immediately backed up. Within minutes, the parking lot was flooding. There were about 15 cars parked in the lot, including Susan Pritchard's white Lexus. I recognized it immediately. The water was spreading across the lot, flowing around the cars, starting to pool. It was muddy and gray, carrying bits of ice and debris from my roof. I stood there recording everything, watching as the water level slowly rose. The lot was large, maybe 100 feet by 200 feet, but the sheer volume of water pouring in was overwhelming the space. Within 20 minutes, there was standing water covering the entire lot, maybe 2 inches deep. The drainage system was completely overwhelmed. By the time the water flow from my roof finally slowed to a trickle around 3 p.m., the parking lot was flooded with 3 to 4 inches of standing water. Every car in the lot was sitting in a muddy pond. Susan's Lexus was right in the middle of the deepest section. I had recorded the entire event in detail. Multiple videos from different angles showing the ice dam failure, the water flowing down the street, and the flooding of the lot. I had timestamps on everything. Then I went back inside and waited. The phone calls started around 4 p.m. The first was from a neighbor asking if I knew what had happened, if there had been a water main break. I played dumb, saying I had been inside working and had not noticed anything. The second call came at 5:15 p.m. from Susan Pritchard herself. She was screaming so loudly I had to hold the phone away from my ear. "What did you do? What the hell did you do? The parking lot is flooded. My car is sitting in 4 inches of water. This is your fault." "Susan, I have no idea what you are talking about. What parking lot? Do not play games with me. The water came from your property, from that ice dam you refuse to fix. Oh, the ice dam melted today because of the warm weather. Yes, I noticed that. But I do not understand how that's connected to the parking lot. That's HOA property, right? The HOA is responsible for maintaining drainage in common areas." There was a long pause on the other end of the line. I could practically hear her brain working. "You did this on purpose," she finally said, her voice low and dangerous. "I did nothing, Susan. An ice dam melted because of warm weather. Water flows downhill. That's basic physics. You could have prevented this. We tried to remove the ice dam for you." "No, you tried to trespass on my property after I explicitly told you I would handle it myself. And I am handling it. The ice dam is gone now. Violation resolved. This is not over. The HOA will be sending you a bill for the damage to the parking lot and to any vehicles that were damaged." The parking lot is HOA property. The HOA is responsible for maintaining it and ensuring proper drainage. If the drainage system failed, that's an HOA maintenance issue, not my problem. Maybe you should have spent less time measuring ice on people's roofs and more time making sure the community infrastructure could handle normal snowmelt. She hung up on me. I sat down at my computer and started drafting an email. I attached all the photos and videos I had taken, documenting the ice dam's growth over the past month, the warm weather event, and the resulting water flow. I wrote a detailed explanation of what had happened, emphasizing that the ice dam had melted due to natural weather conditions, and that water had flowed along public streets to the HOA parking lot, where inadequate drainage had caused flooding. I pointed out that I had offered multiple times to address the ice dam on my own timeline, and that the HOA had refused to grant reasonable accommodation. I sent the email to Susan and the entire HOA board. Then, I sent a copy to a real estate attorney I had found who specialized in HOA disputes. The attorney's name was Marcus Caldwell, and he called me back the next morning. "Mr. Ellis, I read your email and reviewed the attachments. This is quite a situation. Tell me everything from the beginning." I spent an hour on the phone with Marcus, walking him through the entire saga. He asked detailed questions about the bylaws, the violation notices, the fines, and the parking lot flooding. He took notes and occasionally made sounds that could have been either concern or amusement. "Okay," he said when I finished. "Here's my assessment. The HOA has some authority to enforce aesthetic standards, but their application in your case appears arbitrary and excessive. The fines are probably enforceable to some degree, but the amounts are high enough that you could challenge them as punitive. The attempt to send contractors to your property without your explicit consent was legally questionable. As for the parking lot flooding, that's where things get interesting." "How so?" "The HOA has a responsibility to maintain common areas, including drainage systems. If their system failed to handle normal snowmelt runoff, that's a maintenance failure on their part. You did not create an artificial or unusual condition. You allowed natural weather to melt an ice dam, and the water followed natural drainage patterns. The fact that it exposed inadequate infrastructure is not your liability. So they cannot bill me for the flooding. They can try, but you have a strong defense. In fact, you might have grounds for a countersuit. If the HOA has been improperly fining you and acting in an arbitrary manner, you could seek relief from the fines and potentially damages for harassment. What would that involve? Time, money, and stress. HOA litigation is messy. It's neighbor versus neighbor, and even when you win, you lose in some ways because you still have to live in the community. But sometimes it's necessary to establish boundaries and prevent abuse of power. What do you recommend? Let's start by drafting a formal response to the HOA. We will dispute all the fines, explain the parking lot situation, and make it clear that any attempt to hold you financially responsible for their drainage failure will be met with legal action. We will see how they respond. Marcus sent the letter 3 days later. It was 6 pages of dense legalese that essentially said, "Drop the fines, fix your drainage system, leave my client alone." He sent it via certified mail and email. The response from Susan came within hours, and it was not what I expected. Instead of backing down, the HOA board voted to place a lien on my property for the unpaid fines, which now totaled $2,100. They also sent a bill for $8,500 in damages to the parking lot and vehicle repair costs for 3 cars that had supposedly suffered water damage. Marcus was not surprised. They are doubling down. This is typical behavior from HOA boards that have been operating without accountability for too long. They are not used to being challenged. What happens now? Now we file suit. We will ask the court to invalidate the fines and the lien, and we will countersue for damages related to harassment and improper application of HOA rules. We will also seek attorney's fees. This is going to get expensive for someone, and I am going to do my best to make sure it's not you. The lawsuit was filed in early March in Worcester County Superior Court. It named the HOA as the defendant and outlined all my grievances: improper fines, arbitrary enforcement, refusal to allow reasonable time to address violations, attempted trespass by contractors, an improper attempt to hold me liable for damage caused by the HOA's maintenance failures. The local newspaper picked up the story about a week later. A reporter had somehow gotten wind of the lawsuit and called me for comment. I gave him a brief statement about HOA overreach and property rights. The article ran with the headline, "Brookfield Homeowner Battles HOA Over Ice Dam Dispute." It included a photo of the flooded parking lot that someone had taken and posted on social media. That article changed everything. Suddenly, I was getting calls and emails from other homeowners in Meadowbrook Commons and from people in other HOA communities around Massachusetts who had their own horror stories. I heard about fines for garden gnomes, for not repainting houses often enough, for parking commercial vehicles overnight, for children's toys left visible in yards. The stories were endless. A few homeowners from my own community reached out to thank me for standing up to Susan. One of them, the younger woman who had been on the board and had hesitated during the vote to authorize contractor intervention, resigned from the board in protest. Her name was Jennifer, and she sent me a long email explaining that she had only joined the board hoping to make it more reasonable, but Susan controlled everything and made it impossible to dissent. The case slowly moved through the court system. There was a preliminary hearing in April where both sides presented their basic arguments. The judge, a woman in her 60s named Sandra Torres, seemed skeptical of the HOA's position from the start. "Let me make sure I understand," Judge Torres said, looking at the HOA's attorney. "Your client fined Mr. Ellis for having ice on his roof, then attempted to send contractors to his property without his consent, and is now trying to hold him liable for flooding that occurred on HOA property due to natural snowmelt." The HOA's attorney, a nervous-looking man named Philip Rogers, nodded. "Your Honor, the HOA has broad authority under the governing documents to maintain community standards and to take corrective action when homeowners fail to comply with violations. But the ice dam was a weather condition. How is that a maintenance violation? The homeowner could have taken preventative measures such as installing heating cables. Other homeowners in the community did so. Is there a requirement in the bylaws to install heating cables?" "Not specifically, Your Honor, but there is a general requirement to maintain the exterior appearance of properties." Judge Torres turned to Marcus. "Mr. Caldwell, does your client dispute that the ice dam was unsightly?" "No, Your Honor. But we maintain that ice dams are a common winter occurrence in Massachusetts, and that penalizing homeowners for weather conditions is arbitrary and unreasonable. Furthermore, my client repeatedly offered to address the ice dam within a reasonable time frame, and the HOA refused to negotiate. As for the parking lot flooding, that was caused by inadequate drainage infrastructure maintained by the HOA. My client's property simply followed natural drainage patterns during a melt event." The judge made some notes. "I'm going to order mediation. I think there's a possibility for settlement here if both parties are willing to be reasonable. We'll reconvene in 60 days. The mediation was scheduled for early June. Marcus prepared me extensively, explaining that mediation was non-binding, but that it would give us a sense of whether the HOA was willing to compromise. The mediation took place in a conference room at the courthouse, with a court-appointed mediator named David Brennan. Susan Pritchard was there with Philip Rogers and 2 other board members. I was there with Marcus. We sat on opposite sides of a long table like we were negotiating an international treaty. David Brennan was a patient man. He spent 4 hours shuttling between rooms, carrying offers and counteroffers, trying to find common ground. The HOA initially offered to drop the lien if I paid $1,000 in fines, and $2,500 toward the parking lot repairs. Marcus countered with an offer for me to pay $200 in fines if the HOA dropped all other claims, and agreed to amend the bylaws to require mediation before future fines could be assessed. We went back and forth for hours. Susan was immovable on her position that I needed to pay something substantial. She kept saying it was about principle, about making sure homeowners understood they could not just ignore HOA rules. Finally, around 6 p.m., Marcus came back from a session with the mediator and said, "They are not going to settle reasonably. Susan is making this personal. She feels like backing down would undermine her authority. So what do? We go to trial. We prove our case, and we make it expensive enough that the HOA learns a lesson about overreach." The trial was scheduled for September, which gave us months to prepare. Marcus filed multiple motions, took depositions from board members, and subpoenaed HOA documents including all violation notices issued over the past 5 years. What we discovered during discovery was damning. The HOA had issued 247 violation notices over the past 5 years. Of those, 186 had been issued to just 15 homeowners, meaning the enforcement was wildly inconsistent. Several homeowners, including Susan herself, had never received a single violation notice despite having issues that had been cited at other properties. Susan's own property had Christmas decorations up until mid-January one year, 2 weeks longer than the allowed date, but she had never fined herself. Marcus also discovered that the parking lot drainage system had failed inspection reports for 2 consecutive years. The HOA had been advised to upgrade the drains but had not allocated budget for it, choosing instead to spend money on decorative landscaping near the entrance. We also deposed Susan herself. It was the first time I had been in the same room with her since the mediation, and the tension was palpable. Marcus was methodical, walking her through every decision, every fine, every inconsistency. "Mrs. Pritchard, why did you issue a violation notice to Mr. Ellis for an ice dam, but not to the properties at 442 Meadowbrook Lane or 356 Meadowbrook Lane, both of which had visible ice dams during the same time period? I did not notice those ice dams. But you noticed Mr. Ellis's ice dam." "Yes." "Why?" "His was more prominent. It was visible from the street." "Are you saying the other ice dams were not visible from the street?" "I did not notice them." "So your enforcement is based on what you personally happened to notice during your drives around the neighborhood?" "I enforce violations when they are brought to my attention or when I observe them." "Doesn't that create an arbitrary system where some homeowners are cited and others are not, even for identical issues?" Susan's attorney objected, but the point was made. The trial lasted 3 days. It was held in September, with the Massachusetts fall weather just starting to turn cool. The courtroom was small, and the gallery was mostly empty except for a few reporters and some curious homeowners from the community. Marcus was excellent. He presented our case methodically, showing the inconsistent enforcement, the unreasonable fines, the attempted trespass, and the parking lot drainage failure. He called several homeowners as witnesses to testify about selective enforcement. He brought in an engineer who testified that the parking lot drainage system was undersized for the area and had been improperly maintained. The HOA's attorney tried to argue that Susan and the board had been acting in good faith to maintain community standards. He painted me as a difficult homeowner who refused to cooperate with reasonable requests. He tried to make the parking lot flooding sound like an act of intentional sabotage. In his closing argument, Marcus said, "Your Honor, this case is about power and accountability." The HOA has wielded its authority in an arbitrary and excessive manner, targeting Mr. Ellis for a natural weather condition while ignoring identical issues at other properties. When he attempted to resolve the matter reasonably, he was met with escalating fines and threats. When natural weather events caused water to flow across HOA property, exposing years of deferred maintenance on the drainage system, the HOA tried to blame him for their own failures. This is exactly the kind of HOA overreach that damages communities and makes homeownership unnecessarily stressful. We ask the court to invalidate all fines against Mr. Ellis, remove the lien from his property, award damages for the harassment he has endured, and order the HOA to implement fair enforcement procedures going forward. Judge Torres took 2 weeks to issue her ruling. Marcus called me on a Friday afternoon to tell me the decision had come down. We won. On everything. I sat down at my desk, my legs suddenly weak. Everything. The judge invalidated all the fines, ordered the lien removed, awarded you $15,000 in damages, ordered the HOA to pay your attorney's fees, which total about $42,000, and mandated that the HOA adopt new enforcement procedures, including required warnings before fines and mandatory mediation for disputes. She wrote that the HOA's actions were arbitrary, excessive, and contrary to the principles of fair governance. It's a complete victory. I could not speak for a moment. I had been living with this stress for 8 months, and suddenly it was over. What happens now? The HOA has 30 days to comply with the order. They will have to cut you a check, remove the lien, and adopt the new procedures. If they do not comply, we can go back to court for enforcement. Will Susan face any consequences? That's up to the homeowners now. The HOA board can be voted out. With this ruling and all the publicity, I would be surprised if Susan survives the next election. The ruling made the local news again. The headline read, "Judge rules against Brookfield HOA in ice dam dispute, awards homeowner $15,000. The article included excerpts from the judge's decision, particularly the parts criticizing the HOA's arbitrary enforcement and deferred maintenance. Within days of the ruling, a group of homeowners in Meadowbrook Commons organized a petition to call a special election for new board members. They needed signatures from 30% of homeowners to trigger the election. They got 65%. The special election was held in November. Susan Pritchard and all 4 other board members were voted out. The new board was made up of younger homeowners, including Jennifer, the woman who had resigned in protest. One of their first acts was to issue a formal apology to me and to announce a comprehensive review of all HOA practices. The HOA complied with the court order within the required 30 days. I received a check for $15,000 plus another check for $42,000 to pay Marcus's fees. The lien was removed from my property record, and the HOA adopted new enforcement procedures that required written warnings before any fines and mandatory mediation before amounts over $100. In December, almost a year after the ice dam first formed, I received a letter from the new HOA board. It was signed by Jennifer as the new president. Dear Mr. Ellis, on behalf of the new board of Meadowbrook Commons HOA, we want to thank you for your courage in challenging unfair practices. Your case has brought about positive changes that will benefit all homeowners in our community. We are committed to fair, consistent, and reasonable governance. We hope you will consider this a fresh start for your relationship with the HOA. Sincerely, Jennifer Martinez, President. I read the letter twice and then filed it away with all the other documents from the case. A thick folder full of notices, emails, legal filings, and court documents. a record of a fight I never wanted but had no choice but to engage in. That winter, we got another big snowstorm. Ice dams formed on multiple roofs throughout the neighborhood, including mine. The new HOA board sent out an informational email offering resources for ice dam removal and reminding homeowners that while the HOA encouraged proper maintenance, they understood that winter weather was challenging and would work with homeowners to address issues reasonably. I hired a contractor to install heating cables on my roof in January. It cost $800, money I could afford now thanks to the court award. The cables worked perfectly, keeping my roof edge warm enough to prevent ice dam formation even during the coldest stretches. In February, exactly 1 year after the parking lot flooding, I saw Susan Pritchard for the first time since the trial. I was getting my mail at the cluster of mailboxes near the entrance of the community, and she pulled up in her white Lexus. She got out, saw me, and froze for a moment. We looked at each other across the parking lot. I could see the anger still in her eyes, mixed with something else. Humiliation, maybe, or resentment. She turned away without saying a word, got her mail quickly, and drove off. I felt no satisfaction in seeing her like that. The whole situation had been exhausting and had cost everyone involved time, money, and stress. But it had been necessary. Sometimes you have to fight back against petty tyranny, even when it's easier to just comply and move on. The following month, I heard through neighborhood gossip that Susan and her husband had put their townhouse up for sale. They moved out in April, relocating to a single-family home in a nearby town without an HOA. I never saw her again. Life in Meadowbrook Commons settled into a new normal. The HOA under Jennifer's leadership was fair and reasonable. They enforced rules when necessary, but with common sense and flexibility. Violations were rare because people were treated like adults capable of maintaining their properties without constant threats. I stayed in my townhouse for another 3 years before accepting a job offer in Portland, Maine, that was too good to pass up. When I sold the property, I made sure to explain the full history to potential buyers, including the lawsuit and the reforms that had followed. The couple who bought it, young professionals like I had been, were actually excited about the strong homeowner protections that were now in place. On my last day in Brookfield, I drove around the neighborhood one final time. I passed the HOA parking lot, which had been repaved and had a new, properly sized drainage system installed. I drove past Susan's old townhouse, now occupied by a family with young children whose toys were scattered across the small front yard without fear of violation notices. And I drove past my own former home, the townhouse at 428 Meadowbrook Lane, where a simple ice dam had turned into an 8-month battle that changed an entire community's governance. The roof looked good, with snow melting evenly across it thanks to the heating cables the new owners had maintained. As I drove out through the stone entrance gates of Meadowbrook Commons for the last time, I thought about power and accountability, about the importance of standing up for yourself, and about how sometimes the most petty conflicts can lead to meaningful change. The ice dam was long melted, the parking lot had long since dried, but the precedent remained. No future homeowner in that community would face the kind of arbitrary treatment I had endured, at least not without a clear framework for challenging it. I merged onto Interstate 90 heading north toward my new life, leaving Massachusetts behind. But I took with me a valuable lesson. Sometimes the best response to unreasonable authority is not compliance or avoidance, but patient, methodical resistance. And sometimes, letting an ice dam break and flood a parking lot is exactly the catalyst needed to wash away years of accumulated petty tyranny. The story could have ended differently. I could have paid the first fine and moved on. I could have settled during mediation. I could have avoided all the stress and expense of litigation. But then Susan would still be HOA president, still measuring grass with rulers and driving around looking for violations to cite. The next homeowner with an ice dam or a late Christmas wreath or a dandelion in their lawn would face the same treatment. Instead, Meadowbrook Commons got new leadership, new procedures, and a new culture of fairness. It cost me time and energy, but it was worth it. Not just for me, but for everyone who came after. And that, I realized as I crossed the state line into New Hampshire, was the real victory. Not the money or the court ruling, but the systemic change. The ice dam had been temporary. The flooding had lasted a few hours. But the reforms would last for years, protecting homeowners who would never even know my name or understand what their more reasonable HOA had cost someone else to achieve. I smiled as I drove, thinking about the sheer absurdity of the whole situation. An ice dam. A woman with too much time and too much authority. A flooded parking lot. And from that ridiculous combination, actual positive change. Life was strange that way. My phone rang through the car's speakers. It was Marcus Caldwell. "Connor, I just wanted to check in. How's the move going?" "Good. I'm on the road now, actually. Just left Massachusetts. Heading to Portland." "Yeah. New job starts Monday." "Well, I wanted to thank you again. Your case has become something of a landmark in HOA law around here. I have had 3 new clients reference it when they called about their own HOA disputes. You struck a blow for reasonable governance." "I just did not want to pay an unfair fine." Marcus laughed. "That's how it always starts, but you stuck with it and you made a difference. That takes courage." We talked for a few more minutes before hanging up. I drove in silence for a while, watching the late spring landscape roll past. The trees were in full leaf, the sky was blue, and I felt lighter than I had in months. The ice dam seemed like ancient history now, a problem from a different season in a different life. But its effects rippled forward, changing the trajectory of dozens of lives in small but meaningful ways. Every homeowner in Meadowbrook Commons who would benefit from fairer enforcement, every future resident who would avoid arbitrary fines, every person who would serve on the reformed HOA board and help maintain the new culture of accountability. They were all part of the story that started with ice on my roof and water flooding a parking lot. I had learned something valuable through the experience. Institutions, even small ones like HOA boards, require constant vigilance to prevent abuse. Power, even the tiny amount wielded by a neighborhood association president, can corrupt when left unchecked. And ordinary people, when pushed far enough, can create change through persistence and a willingness to endure short-term pain for long-term improvement. As I drove north toward a new chapter of my life, I felt grateful for the lessons, despite the difficulty of learning them. The ice dam had melted away months ago, but what it revealed about fairness, justice, and the importance of standing up against petty tyranny would stay with me forever. And somewhere behind me, in a suburban Massachusetts townhouse community, a new HOA board was learning to govern with reason and fairness, treating homeowners with respect instead of suspicion. That was the real ending to the story, the part that mattered most. The ice dam was gone. The water had dried, but the change remained, frozen into the new bylaws and procedures, a permanent record of what happens when someone decides that enough is enough and refuses to back down. That was worth more than any court award or personal satisfaction. It was systemic change, born from ice and water and stubborn determination, and it would outlast all of us.